Hello. Hey, everybody. I'd like to say happy Monday, but y'all know I cannot stand Mondays. But happy second Sunday in that case, anyway. And if you're okay with Mondays, well, I hope it's a good one for you. Well, I got something a little different today for you. Um, for me, this was the most amusing, um, rather, well, the whole case of it wasn't actually amusing, but how it's turning out is actually quite amusing. It's been going on for, mm, oh, the legal case itself has been going on for more than a year. However, the antics that make it pretty much amusing have only been about a month or so, and most recently just like right. Yeah, Charlie. Hi. Tuesday is just Monday 2.0. Yeah, this is true. Or just second Sunday. Like I say, I'd rather keep Sunday, because why not, right? Well, let me give you a little backstory first before I get into the shenanigans. Okay. This is about the case of Anthony Novak versus the city of Parma. Okay. And basically it is, uh, it goes all the way back to 2016. Okay. All right. In Back in March of 2016, in the city of Parma, in the state of Ohio, a resident by the name of Anthony Novak created a page on Facebook mimicking that of the Parma Police Department. Um, they have a slogan that was "We know crime," like KNOW, like we know it, right? So he created a a Facebook page that says "We know crime," like NO, like to be smarty, and in the about section, he anonymously from his phone while waiting for a boss, he put criticism on there about the department's policies. He posted on the page job posting discouraging applicants by members of minorities, and he also said that there would be, you know, free terminations for teenagers provided to the police in the Walmart parking lot. He was pretty snarky about it, and it was parody, and it was the thing is, like, anybody looking at it, I think, would think that it was a parody, and a joke, but uh, apparently, the Parma Police Department did not, because also they arrested him. A few weeks after the page's brief existence, he was charged with disrupting public services, a fourth-degree felony, and he spent 3 or 4 days in jail. And he was indicted that April. At the trial in what uh, what what happened in August of 2016, prosecutors argued that Novak's actions had disrupted police activities. Novak's attorney, of course, countered the department's statements at the time, focused on the derogatory nature of Novak's comments and said, "Well, I'm sorry, but it's parody. Like it was a joke." Okay. The jury did acquit Novak. And Novak immediately announced plans to sue. Okay. Well, we go forward to October of 2017, and you know what? He sues. Okay. He brought a federal suit in the Northern District of Ohio against the city of Parma and two of the investigating officers, who decided that, he had done these violations. He alleged that it was retaliation and prior restraint in violation of the First Amendment and violations of the Fourth Amendment. Okay. Well, the city, of course, they put out a motion to dismiss, asserting that they had qualified immunity. Now, do you know what qualified immunity is? Let me just explain. That is when you work with the government or in some official I'm sorry to be disrupted, but yay! Let me just put that. Okay. I'm really bad at this stuff. Let me see if I can just get this up here really quick for you. Oh, it doesn't. Oh, members, you know that. Members' messages won't pop up in StreamYards, but yay. EKC People Suck. Member for 5 months. A murder minion says yay alive from the beginning. And oh, hi, Claire. Hey, Aaron. How you doing? I'm glad you caught this one. This is funny. This is right up your alley, actually. This is snarky as all hell. Okay. So, anyway, The city, of course, moved to dismiss basing qualified immunity, and that is protection of anybody working, like say in the armed forces, or protecting the people, like say a fire department, police department, or the federal government from civil suit by a citizen in when they are performing their duties. Okay, within the scope of their jobs, they cannot be sued, regardless of what happens. And in many cases, that is absolutely necessary. I mean, how could you be a police officer and perform your duties and worry about people suing you left and right? Qualified immunity is necessary, but is it necessary against a parody account? I'm not so sure, but it I don't know. Can you see where I'm going here? It just gets better. Okay. So anyway, the district judge, which is the local judge, which was Judge Polster, denied most parts of the city's motion to dismiss and allowed the suit to go forward as of April of 2018. However, on appeal in July of 2019, the Sixth Circuit dismissed Novak's claim and related to anonymous speech, censorship to the public forum, and the right to receive speech, but allowed the case to proceed otherwise. In other words, the speech part, like they don't feel like he was inhibited from speaking since he actually did do all of the posting and everything, but now he's being actually penalized for it. Okay, so another judge, Judge Thaper, voting for a unanimous 3-judge panel, stressed, and I quote, our nation's long held First Amendment protection for parody does not rise and fall with whether a few people are confused. And that parody is judged by a reasonable reader's standard, not a most gullible person on Facebook standard. Let me just clap for that one. Yo, judge. Because, like, no, we don't go down to the lowest to make our judgment. We go to the middle, like reasonable, right? Like, we don't go down to the bottom on that. Okay, so that was absolutely like brill. I mean, that is the professional part of all of this. I mean, and when I tell you it gets better, it just gets better. We're only in 2019 now. Yes, we're only in 2019. We got years to go. Okay, so this is going back and forth. And of course, they're going to go to the Supreme Court, right? You could just smell it already, can't you? Like, no, these people are having too much fun bopping this thing back and forth on whether or not a damn parody account can exist on Facebook because somebody's fifis got hurt. Now, I understand it was a police department, and I do understand that they have an image to upkeep. I'm not I understand the point. Believe me, I'm not scouting around it. Okay, I get it. And some people are going to be offended because it was a police department. Okay, but when you take into consideration that that particular police department had a lot of rumors going around it about their treatment of minorities, about what was going on with minors, and a lot of things. A lot of the parody was taken right from things that were going on in the headlines, in the statistics, and locally in the area. Isn't that how parody is done? You take a real issue and you make light of it a little bit. You actually do a commentary on the issue with some snark, with a little some jabs, some barbs, a little bit of roasting. That's parody, right? I mean, correct me if I'm wrong. I mean, but that's how I thought it went. I mean, that's parody, right? And parody should be protected. And it usually is. But when you retaliate because your fifis are hurt and you're that government official capacity, or in this case, the police department, and you go and arrest the person for making fun of you because that's what they did, right? Nobody was really hurt by this. There was not an extra amount of calls made to the police department. They didn't stop anybody from going out on calls and protecting people or for doing their jobs. The people that saw it online just got their fifis hurt that worked for the police department. And somebody got their nose out of joint and they arrested him. It said, you can't do that. You can't make fun of us. Should qualified immunity apply in this case? That's the real issue there legally. Does that really seem to be something that qualified immunity should cover? Your feelings getting hurt. I mean, did he really actually break the law by making fun of the police station? What law did he break? Actually, they're saying that he caused all these rookies people laughing at you and pointing at you and saying, "Oh, I get the joke," I don't think that that is exactly harmful. But they had another opinion about it, and I'm real curious to find out how you guys feel about it. Because it's just me. I could be way out there on this one. I don't know. All right. So the court noted that the United States Supreme Court statement in a case called Grecky and Howard's that this court has never recognized a First Amendment right to be free from a retaliatory arrest that is supported by probable cause. And the general rule under Neves versus Bartlett that a plaintiff cannot sue for retaliatory arrest if probable cause existed. It found that Novak's speech did not fall under the exception rule made in Lozman versus the city of Riera Beach for official policies of retaliation. Yes, there are official policies of retaliation. I found that interesting. And found that the exception made in the Neves laws that are rarely enforced could not be invoked because the Supreme Court's decision in Neves postdated the arrest. In other words, well, they arrested him first, and then this other thing happened in a court, and now it's case law, and we can't use it because the arrest was prior. Okay. In February 2021, Polster found that the officers had probable cause to arrest Novak and that they had followed the proper procedures and had not been hot headed police officers seeking revenge, and that they had qualified immunity. Okay. So the Supreme Court said, okay, we're gonna let it go with qualified immunity. What we're having some of we're gonna let it go forward. But listen, now it's got to go up there and they've got to really look at it because it's being appealed. Okay. A unanimous 3-judge panel of the Sixth Circuit affirmed Polster's ruling in April of 2022, just this April. Thaper, again writing for the panel, expressed the court's doubts about the decision to prosecute Novak, but agreed that the city and officers had qualified immunity. Unlike in the 2019 decision, in which the court had implied that probable cause could have come only from Novak's speech. Thaper wrote that it was reasonable for the officers to think that Novak might have been impersonating a police officer, which, unlike parody, is not protected speech. Thus, he reasoned there was probate cause for the arrest and it could not be retaliatory under the other case laws of Neves. Okay. The court also rejected Novak's Fourth Amendment claim, malicious prosecution, prior restraint, and municipal liability claims, and found that the officers had statutory immunity against a jumble of state law claims because they did not act with malicious purpose or in bad faith or in any reckless manner. Okay. Well, it didn't go down too good. Okay, because you know what is going to happen next. Okay. Because Novak filed a petition for a writ of certiorari from the United States Court on September 2022, represented by attorneys from the Institute for Justice. Okay. Now, in law, certiorari, I don't even know if I said that right, is a court process that you seek judicial review of a decision of a lower court or a government agency. All right. It comes from the name of, prerogative writ when it's issued by the superior court to direct that record to a lower court and be sent to the superior court for review. It kind of means in Latin, like double check or to make, actually, when you translate it from Latin, and I'm using Google here. No, I'm not a genius to stop that. Okay. It does mean to be made certain. So it's like a double check. Okay. We wish to look at this again to make sure we're doing the right thing. Okay. So that's what that means. And he wants them to look at it again. He's like, whoa, wait a minute. Wait a minute. Wait a minute. You need to look at that too. Okay. So now I got you caught up to where it is in the court. He's up there at the Superior Court again. Okay. It's back to the Supreme Court for another double look-see to make sure. Are you sure? Are you sure? Because we're talking First Amendment here. We're talking parody. I never left my house. I'm not impersonating anybody. But if I make a parody account about a police officer, does that mean I'm actually impersonating a police officer? Like, I'm talking about the whole organization here. Like, it's an obvious joke. It was obvious to everybody who saw it that it was a joke. Okay. It was so outlandish, it had to be a joke. Okay. But, hmm, like, where's the line? Okay. And apparently, with this going back and forth, all from 2016 to now, actually now, right now, I can't believe it's going back and forth this much. And there's that they haven't decided yet. Okay. No, no, Propsky, it wasn't Pat Novak. It's Anthony Novak, a real live person who made a parody on Facebook. Yep. Real life, true story. Okay. So, all right. That's enough of the backstory because it just gets better. It just gets better. And you're going to have to indulge me. I'm going to have some fun with this one. This lit me up like I can't tell you. All right, let me just read from the chat. Autistic Shill, member for 7 months, Mayhem member. I swear I already had 7 months. Weird, but year, it's going way too fast. It really is. And thank you. And thanks for being a member and a mod, Shill. I love having you here. Grace Case member for 6 months, a murder minion. Me too, me too. I'm not going to leave you out. It's good to see you here too. And yo, Dark Magician, so nice to see you here. Thank you for coming by. Robski, it's so nice to have you here in the chat. I hope you're having a good day. And everybody else who I didn't, the Turtle Moves, Always Createful. Hey, the Rocket Couch. Nice to see you too. MC Wrecker, Icarus. Great to see you guys. The Mousy Files and Student. If you're still here, Godless Granny, if you're still listening, thank you. I'd love to know what you think about this, Godless Granny, if you are actually listening, because this is hysterical to me. And does have really good legal case law. I mean, it's really fascinating on the issue when you think about it, because we're talking about on this hand, free speech, on that hand, parody. Anybody, does that sound familiar to anybody lately? If you've been following the social media platforms, do you think that we might have like the same thing going on with Twitter right now? Okay. So this is important. I wonder if Elon's following this case. I wonder if he's looking to see what's going to happen with this and everybody out there. I wonder. I just wonder. It's just too good. It's just too good. Okay. So let's go into the future a little bit. Last month, you may have saw some posts from The Onion. Yeah, that snarky, rhetorical, or I guess it's a web page commentary, like news page kind of thing. Okay, here's a link to it if you haven't. They make fake articles and memes and stuff about real stuff going on, and it's all parody. It's all snark. It's all supposed to be funny. Okay. Um, the issue is important. I agree. Always creative. I do. I absolutely agree with the issue, but it's just hitting my funny bone. Like I can't even. I'm sure you can hear. I can hardly stop from laughing as I'm talking about it because it's weird but true. Like funny but true. You know what? It's funny because it is true that it's going on. And that's what makes it even more funny. And I hope you did like that Amicus brief, because guess what I'm going to read? I'm going to read the fact that the Onion hired lawyers and wrote a brief, and an Amicus brief. Now, an Amicus brief is when you let me just get you the official so I don't muck it up on you. But basically, an Amicus brief, okay, it means, friend of the court, loosely translated from Latin, but an amicus brief is generally referencing a person or a group, is not party to the action. In other words, they're not named in the suit, but has a strong interest in the matter. In other words, the outcome of this case matters to me a lot. Okay, and that's what the Onion was saying when they sent in their amicus brief. Okay, the person or the group, they petition the court for permission to submit a brief, in the action intending to influence the court's decision. In other words, they're like, yo, judge, I got something to say about that. Could you take this into consideration while you're going over this issue? Would you read this for me, please? And, maybe like look at a couple of the points I'm making here. All right. But these kind of briefs are called amicus briefs, and they're just submitted by people who are not actually named. Okay. All right. Mhm. Yeah, like a pelican brief, but different, Charlie. No bill. Anyway, um, mm, all right. So if if I can keep the snark out of my voice, which I don't know, maybe not. It's kind of iffy if I can, if I actually can. Um, that doesn't look very good. I'll do this one. Okay. Ah, why is that up there? Okay. All right. So here we go. All right. You got to read the table of contents because even the table of contents is pretty funny in this. But I kid you not, this was filed. Supreme Court of the United States, number 22-293, Anthony Novak, petitioner, versus the city of Parma, Ohio, Kevin Riley and Thomas O'Connor, individually in their official capacities as employees of the city of Parma, are the respondents. On petition for a writ of certiorari, whatever I said that, to the United States Court of Appeals for the Sixth Circuit, brief of the Onion as amicus curiae in support of the petitioner. Okay, and yup, there they are. Table of contents. It's real. I'm telling you, it's real. I kid you not. It's going to go over the interest of the amicus, introduction and summary of the argument. They're going to give an argument. Here's the parts of the argument. Number one, parody functions by tricking people into thinking that it is real. Argument number two, because parody mimics the real thing, it has the unique capacity to critique the real thing. Makes sense to me. Argument number three, a reasonable reader does not need a disclaimer to know that parody is parody. Because how funny is it if you go, yo, joke on the way, pay attention. Oh, hey, parody over here, take notice. If that's not what parody is about. A parody is that you look at it, it looks like the other thing. You know it's not, but it's funny in its commentary on the other thing. I don't know. It's just like absolutely asking for too much to label it as parody if it's going to be parody. I don't know. But apparently, Elon did get a look at this because that's what he was saying on Twitter. Like all these parody accounts, you have to put parody on it so that we know you're a joke. Like you really you do. You got to put parody out there or I don't know you're funny. It's like, I don't know. I have issues. Number 4. It should be obvious that parodists cannot be prosecuted for telling a joke with a straight face. And then there will be a conclusion. So, here we go. Yeah, we're going in. Oh, and cases, people, look at this, look at this. They ain't kidding. They got case law. They got case law. There you go. And authorities and other authorities. Case law. Okay. And more case law. They're not kidding, but they're kidding. Okay. Interest of the Amicus Curiae. The Onion is the world's leading news publication, offering highly acclaimed, universally revered coverage of breaking national, international, and local news events. Rising from its humble beginnings as a print newspaper in 1756, The Onion now enjoys a daily readership of 4.3 trillion and has grown into the single most powerful and influential organization in human history. Yeah, they're going there. Mhm. They're snarking the court. In addition to maintaining a towering standard of excellence to which the rest of the industry aspires, the Onion rather, supports more than 350,000 full and part-time journalism jobs in its numerous news bureaus and manual labor camps stationed around the world. And members of its editorial board have served with distinction in an advisory capacity Mm. In an advisory capacity for such nations as China, Syria, Somalia, and the former Soviet Union. On top of its journalistic pursuits, The Onion also owns and operates the majority of the world's transoceanic shipping lanes, stands on the nation's leading edge on matters of deforestation and strip mining, and proudly conducts tests on millions of animals daily. The Onion's keen, fact driven reportage has been cited favorably by one or more local courts, as well as Iran and Chinese state run media. Okay. Mm. The footnotes are important here. No counsel for any party authored this brief in whole or in part, and no counsel or party made a monetary contribution intended to fund the preparation or submission of this brief. Timely notice of the intent to file this amicus brief was provided to all parties, and all parties have consented to the filing of this brief. Along the way, the Onion's journalists have garnered a sterling reputation for accurately forecasting future events. One such coup was the Onion's scoop, revealing that a former president kept nuclear secrets strewn around his beach home's basement 3 years before it even happened. The footnote number 2. See Mar-a-Lago assistant manager wondering if anyone coming to collect nuclear briefcase from Lost and Found from The Onion, March 27, 2017. The Onion files this brief to protect its continued ability to create fiction that may ultimately merge into reality. As the Globe's premier parodists, The Onion's writers also have a self serving interest in preventing political authorities from imprisoning humorists. This brief is submitted in the interest of at least mitigating their future punishment. Introduction and summary of the argument. Americans can be put in jail for poking fun at government. This was a surprise to America's finest news source and an uncomfortable learning experience for its editorial team. Indeed, Ohio police officers arrest, prosecute man who made fun of them on Facebook. Might sound like a headline ripped from the front pages of The Onion, albeit one that's considerably less amusing because its subjects are real. So when The Onion learned about the Sixth Circuit's ruling in this case, it became justifiably concerned. First, the obvious. The Onion's business model was threatened. This was only the latest occasion on which the absurdity of actual events managed to eclipse what the Onion staff could make up. Much more of this, and the front page of the Onion could be indistinguishable from the New York Times. Second, the Onion regularly pokes its finger in the eyes of repressive and authoritarian regimes, such as the Islamic Republic of Iran, the Democratic People's Republic of North Korea, and domestic presidential administrations. So the Onion's professional parodists were less than enthralled to be confronted with a legal ruling that fails to hold government actors accountable for jailing and prosecuting a would be humorist simply for making fun of them. Third, the Sixth Circuit's ruling imperils an ancient form of discourse. The court's decision suggests that parodists are in the clear only if they pop the balloon in advance by warning their audience that their parody is not true. But some forms of comedy don't work unless the comedian is able to tell the joke with a straight face. Parody is the quintessential example. Parodists intentionally inhabit the rhetorical form of their target in order to exaggerate or implode it, and by doing so, demonstrate the target's illogic and or absurdity. Put simply, for parody to work, it has to plausibly mimic the original. The Sixth Circuit's decision in this case would condition the First Amendment's protection for parody upon a requirement that parodists explicitly say upfront that their work is nothing more than an elaborate fiction. That would strip parody of the very thing that makes it function. The Onion cannot stand idly by in the face of ruling that threatens to disembowel a form of rhetoric that has existed for millennia, that is particularly potent in the realm of political debate, and that purely, incidentally, forms the basis of the Onion's writers' paychecks. So we get to the argument. Number one, parody functions by tricking people into thinking that it is real. To, to stultus, you are dumb. These three Latin words have been the Onion's motto and guiding light since it was founded in 1988 as America's finest news source, leading its writers towards the paper's singular purpose of pointing out that its readers are deeply gullible people. The Onion's motto is central to this brief for two important reasons. First, it's Latin. And the Onion knows that the federal judiciary is staffed entirely by total Latin dorks. They quote Catullus in the original Latin in chambers. They sweetly whisper stare decisis into their spouses' ears, and they mutter Chiovono under their breath while picking up after after their neighbors' dogs. So the Onion knew that unless it pointed to a suitably Latin rallying cry, its brief would be operating far outside the court's vernacular. The second reason, perhaps mildly more important, is that the phrase, you are dumb, captures the very heart of parody, tricking readers into believing that they're seeing a serious rendering of some specific form, a pop song lyric, a newspaper article, a police beat, and then allowing them to laugh at their own gullibility when they realize that they've fallen victim to one of the oldest tricks in the history of rhetoric. See San Francisco Bay Guardian versus Superior Court and the case laws there. The very nature of parody, I quote, is to catch the reader off guard at first glance, after which the victim recognizes that the joke is on him to the extent that it caught him unaware. It really is an old trick. The word parody stretches back to the Hellenic world. It originates in the prefix para, meaning an alteration, and the suffix ode, referring to poetry form known as an ode. Oxford English Dictionary online. You can look it up, people. See online etymology dictionary, and there's a link. It was last updated on October 13th, 2021. I love the footnotes. One of its earliest practitioners was the first century BC poet Horace, whose satires would replicate the exact form known as an ode, mimicking its meter, its subject matter, even its self serious tone, but tweaking it ever so slightly so that the form was able to mock its own idiocies. Horace, Satires Apostles of Ars Poetica from page 196 to 97, translated by Harvard University Press in 1926, and they give you a link so you can find it yourself. This is not a mere linguistic anecdote. The point is instead that without the capacity to fool someone, parody is functionally useless, deprived of the tools inscribed in its very etymology that allow it again and again to perform this rhetorically powerful sleight of hand. It adapts a particular form in order to critique it from within. See case law, Farah versus Esquire magazine. Parody leverages the expectations that are created in readers when they see something written in a particular form. This could be anything, but for the sake of brevity, let's assume that it is a newspaper headline, maybe one written by The Onion, that begins in this familiar way: Supreme Court rules. Already one can see how this works as a parodic setup, leading readers to think that they're reading a newspaper story with just three words. The Onion has mimicked the dry tone of an Associated Press news story, aping the clipped syntax and the subject matter. The Onion could go even further by putting the headline on its website, which features a masthead in Latin motto, and the design of which parodies the aesthetics of major news sites, further selling the idea that this is an actual news story. Of course, what moves this into the realm of parody is when The Onion completes the headline with the punchline, the thing that mocks the newspaper format. The Onion could do something like, Supreme Court rules, Supreme Court rules. The Onion could push the parody even further by writing the joke out in article format with, say, a quote from the justices in the majority, opining that while the U.S. Constitution guarantees equality of power among the executive, legislative, and judicial branches, it most definitely does not guarantee equality of coolness. And rounding off by reporting the Supreme Court's holding that the court rules and rules totally, all worthy and touched by nobody in perpetuity and in accordance with Article 3 of the U.S. Constitution. The ability of the President and Congress to keep pace with us is not only separate, but most unequal. As can be seen, the Associated Press form is followed straight through into the article. That rhetorical form sets up the reader's expectations for how the idiom will play out. Expectations that are jarringly juxtaposed with the content of the article. The power of the parody arises from that dissonance into which the reader has been drawn. Farah, case law. Here's another example. Assume that you are reading what appears to be a boring economics paper about the Irish overpopulation crisis of the 18th century, and yet, strangely enough, it seems to advocate for solving the dilemma by cooking and eating babies. That seems a bit cruel until you realize that you are, in fact, reading a modest proposal. To be clear, The Onion is not trying to compare itself to Jonathan Swift. Its writers are far more talented, and their output will be read along after the hack Swift has been lost to the sands of time. Still, The Onion and its writers share with Swift the common goal of replicating a form precisely in order to critique it from within. That leverage of form, the mimicry of a particular idiom in order to heighten dissonance between form and content is what generates parody's rhetorical power. Campbell versus Acuff Rose Music Inc. Case law. Again, parody needs to mimic an original to make its point. If parody did not deliver that advantage, then no one would use it. Everyone would simply draft straight, logical, uninspiring legal briefs instead. Here, here. Okay, I need to take a sip. Mm, mhm, mm. Okay. Mm. Have I lost you all yet? Because this, it just gets better. It just keeps getting better. Okay. Argument number 2. Here we go. I'm all down with argument number 1. I don't know about you guys. I'm all down for this. Because parody mimics the real thing, it has the unique capacity to critique the real thing. Importantly, parody provides functionality and value to a writer or a social commentator that might not be possible to say simply stating a critique outright and avoiding all the confusion of readers mistaking it for the real deal. One of parody's most powerful capacities is rhetorical. It gives people the ability to mimic the voice of a serious authority. Whether that's the dry news speak of the Associated Press or the legalese of a court's majority opinion, and thereby kneecap the authority from within. Parodists can take apart an authoritarian's cult of personality, point out the rhetorical tricks that politicians use to mislead their constituents, and even undercut a government institution's real world attempts at propaganda. Case law Farah. Noting that the point of parody is to censor the vices, follies, abuses, or shortcomings of an individual or society. And they say they cleaned that one up. Time and again, that's what has occurred with the Onion's news stories. In 2012, for example, the Onion proclaimed that Kim Jong Un was the sexiest man alive. Remember that? Kim Jong-un was the sexiest man alive. And that did happen in November 14th of 2012. And they're quoting the article right down below in the footnote. Listen. China's state-run news agencies republished the Onion's story as true alongside a slideshow of the dictator himself in all his glory. And there's another footnote because yes, they did. As John Bacon, China paper falls for spoof of sexiest Korean leader, which came out on November 27th of 2012 in USA Today. The Fars Iranian news agency uncritically picked up and ran with the Onion's headline Gallup poll, rural whites prefer Ahmadinejad to Obama. Domestically, the number of elected leaders who are still incapable of parsing the Onion's coverage as satire is daunting. But one particular example stands out. Republican Congressman John Fleming, who believed that he needed to warn his constituents of a dangerous escalation of pro-choice movement after reading the Onion's headline Planned Parenthood opens 8 billion abortion plex, an $8 billion abortion plex. And that came out on September 28th of 2012. Mhm. Mm. Oh, no, that came out on February 6th of 2012. I'm sorry, wrong story. The point of all this is not that it is funny when deluded figures of authority mistake satire for the actual news, even though that can be extremely funny. Rather, it's that parody allows these figures to puncture their own sense of self importance by falling for what any reasonable person would recognize as absurd escalation of their own views. In the political context, the effect can be particularly pronounced. See Hustler magazine versus Falwell. In a quote, First Circuit of 1986. Okay. Wilkinson J., dissenting from denial of the rehearing. Nothing is more thoroughly democratic than to have the high and mighty lampooned and spoofed. And I agree. Argument number 3. No, I didn't say that, Casey, but I could have. I could have. I could have. No, I did not say that. but I Anyway, a reasonable reader, number 3, a reasonable reader does not need a disclaimer to know that parody is parody. Okay? At bottom, parody functions by catering to a reasonable reader, one who can tell, even after being tricked at first, that the parody is not real. If most readers of parody didn't live up to this robust standard, then there would be nothing funny about the Chinese government believing that a pudgy dictator like Kim Jong un was the sexiest man on earth. Everyone would just agree that it was perfectly reasonable for them to be taken in by the headline. The law turns on the same reasonable person construct. The reasonable reader test gauges whether a statement can reasonably be interpreted as stating actual facts, thereby ensuring that neither the least humorous nor the most credulous audience dictates the boundaries of protected speech. Milkovich versus Lorraine, case law. Mink versus Knox, case law. Moldia versus New York Times. See also Gold versus Attorney General of New York. Okay. And we quote, a parody enjoys First Amendment protection, notwithstanding that not everybody will get the joke. And the reasonable reader is no dullard. He or she does not represent the lowest common denominator, but reasonable intelligence and learning. He or she can tell the difference between satire and sincerity. Case law, New York Times versus Isaacs. Okay. And we quote from him, nor is the reasonable person some totally humorless drudge who cannot perceive the presence of subtle invective. Patrick, 27 cal from at page 887. Instead, the reasonable reader's perspective is more informed by an assessment of her well-considered view than her immediate yet transitory reaction, particularly in light of the special characteristics of satire, which leverage that transitory reaction for rhetorical effect. Pharaoh, case law. Listen, context matters, but even a poorly executed parody is ordinarily susceptible to the intellectual grasp of the reasonable reader. From Pharaoh, reasonable readers do not need to be told explicitly they have no serious trouble figuring out for themselves. And until the Sixth Circuit's decision, that is what most courts have held. Some courts have expressively held that disclaimers aren't required for parody to be protected. Campbell, case law, for example, noted that there is no reason to require parody to state the obvious. Cliff's Notes in versus Bantam Doubleday. There is no requirement that the cover of a parody carry a disclaimer that it is not produced by the subject of the parody, and we ought not to find such a requirement. Other courts have held that parody published without a disclaimer are nonetheless protected speech. For example, the New York Stock Exchange versus Gahari. Mhm. Entirely plausible that no one in their right mind would believe that the defendant, who posted obscene and vulgar messages online under the persona Richard Grasso, was the real life Richard Grasso, the CEO of the New York Stock Exchange. The court in the New York Times similarly rejected the notion that the absence of a disclaimer was dispositive, noting that the reasonable reader had other obvious clues that an article was parody when it reported that a 6-year-old girl was being prosecuted for her book report on Morris Sendak's Where the Wild Things Are and included a photo of a small child holding a stuffed animal captioned, "Do they make handcuffs this small? Be afraid of this little girl." See also Patrick case law. No reasonable reader would have been deceived by a memorandum purportedly written by a judge that declared a certain legal newspaper contraband, announced a chambers by chambers search for copies of the publication, advised fellow judges and employees to conduct their amorous escapades elsewhere while the search was being conducted, and declared the judge's intent to suspend the election of his successor and remain in office indefinitely. In this case, by contrast, the Sixth Circuit ruled that the defendant's officers could reasonably believe that some of Novak's Facebook activity was not parody, primarily because Mr. Novak deleted comments that made clear the page was fake. But the lack of an explicit disclaimer makes no difference to whether a reasonable reader would discern that this speech was parody. Just to be clear, this was not a close call on the facts. Mr. Novak's spoof Facebook post advertised that the Parma Police Department was hosting a pedophile reform event in which successful participants could be removed from the sex offender registry and become honorary members of the department after completing puzzles and quizzes, that the department had discovered an experimental technique for abortions and would be providing them to teens for free in a police van, that the department was soliciting job applicants, but that minorities were strongly encouraged not to apply, and that the department was banning city residents from feeding homeless people in an attempt to have homeless people population eventually leave our city due to starvation. Yep, those were the parodies. True, not all humor is equally transcending, but the quality and taste of the parody is irrelevant. See Hustler versus Penthouse, or Prig versus Penthouse case law. And we quote, extending First Amendment protections to a parody that had no redeeming features whatsoever. And there is no real doubt that reasonable readers would have no difficulty in asserting that Parma's finest were not actually providing free abortions to teens in a police van, pardoning child sex offenders on the basis of their adeptness at puzzles, or intentionally starving the homeless. The absence of a disclaimer lends nothing to the analysis. Under a proper understanding of the reasonable reader test, a disclaimer not only spoils the punchline, but it's redundant. The Sixth Circuit's holding stands alone among the otherwise uniform approach courts have taken, and not in a good way. Argument 4. It should be obvious that parodists cannot be prosecuted for telling a joke with a straight face. You would think. This is the 15th page of a convoluted legal filing intended to deconstruct the societal implications of parody. So the reader's attention is almost certainly wandering by now. And that's understandable. And I feel for you people, I do, but I'm going to carry on. So here is a paragraph of gripping legal analysis to ensure that every jurist who reads this brief is appropriately impressed by the logic of its argument and the lucidity of its prose. And I can't say all of this, but I'm going to try. So, for all you Latin enthusiasts out there, I apologize in advance. Okay. Bona vacantia, de bonus asperatus, writ de certiorari de minimis. Jos ascrescendi forum non conveniens corpus juris ad homine tuquo post hoc ergo propria hoc quod est demonstratum actus rus scandalum magnatum. I like that one. Can I say it again? Scandalum magnatum and pactum reservati domini. Okay. See what happened? See what happened? This brief itself went from a discussion of parody's function and the quite serious historical and legal arguments in favor of strong protections for parodic speech to a curveball mocking the way legalese can be both impenetrably boring and belie the hollowness of the legal position. That's the setup and punchline idea. It would not have worked quite as well if this brief had said the following. Hello there, reader. We are about to write an amicus brief about the value of parody. Buckle up because we're going to be doing some fairly out there things, including commentating on this text form itself. Taking the latter route would have spoiled the joke and come off as a bit stodgy. But more importantly, it would have disarmed the power that comes with a form devouring itself. For millennia, this has been the rhythm of parody. The author convinces the readers that they're reading the real thing, then pulls the rug out from under them with the joke. The heart of this form lies in that give and take between the serious setup and the ridiculous punchline. As Mark Twain put it, the humorous story is told gravely. The teller does his best to conceal the fact that he even dimly suspects that there is anything funny about it. Not only is the Sixth Circuit on the wrong side of Twain, but grafting onto the reasonable reader test a requirement that parodists explicitly disclaim their own pretense to reality is a disservice to the American public. It assumes that ordinary readers are less sophisticated and more humorless than they actually are. And the stakes here are significant, involving no less than one of many more or less equally important components of social and political discourse. Rhetorical hyperbole has traditionally added much to the discourse of our nation. From Miklovich, case law, although, quote, parody is often offensive, it is nevertheless deserving of substantial freedom, both as entertainment and as a form of social and literary criticism. LL Bean Inc. versus Drake Publishers. The court has traditionally been hesitant to chill speech, and this prospect of chilling parody by imprisoning its practitioners provides equal cause for caution. What may be difficult to communicate or understand when factually reported may be poignant and powerful if offered in satire from Rogers versus Grimaldi, case law. And here we quote, the last thing we need, the last thing the First Amendment will tolerate is a law that lets public figures keep people from mocking them. Cartoons, LC versus Major League Baseball players. And quoting White versus Samsung elects, with Judge Kazenti dissenting, of course. The Onion intends to continue its socially valuable role, bringing the disinfectant of sunlight into the halls of power. See Buckley versus Vallow case law. Quoting Louis D. Brandeis, Other People's Money and How the Bankers Use It, 62, the National Home Library Foundation. And it would vastly prefer that sunlight not be measured out to its writers in 15-minute increments in an exercise yard. And in conclusion, the petition for certiorari should be granted, the rights of the people vindicated, and various historical wrongs remedied. The Onion would welcome any one of the three, particularly the first. Done. Hmm. Well, we're done, but we're not done. I hope my voice isn't annoying you, but that was absolutely funny to me. And yes, always creative. Although I mangled the Latin, I loved their use of Latin. Okay. Do you guys see what's going on here? Okay. These are real issues. This is a real issue. Free speech versus parody. Where are the lines? Okay. This is going on Twitter right now. This is going on everywhere in social media. Okay. They say they want to make a safer platform. They want to be able that we all can express our opinions. And I'm all for that. We all can express our opinions. But the lines have to be drawn somewhere on certain things. Is it on parody? Is it on misinformation? Is it on the damage that gets caused? Is it on threatening and violence of opinion? Like, you should have known I didn't mean it when I said I wanted to wring your neck. Or could it be like misinformation that actually gets people hurt? Okay. I am actually overwrought with all the possibilities that this silly amicus brief is causing at the Supreme Court. But it gets better. Does anybody know of this other yeah, it's a conservative, it's kinda like the conservative jabby version of the Onion. It's called, the Babylon Bee, okay? There's a link to them. I wanna promote them too because, they couldn't leave it alone because just last week, they went and submitted their own amicus brief. I kid you not. They submitted an amicus brief right after, to kind of go against the Onion, okay? But they're supporting the government. And oh yeah, this one's just as good. It's just as good. Um although I might choke a little more as I read this one. And I'll try not to keep you too much longer. Um is Charlie, I don't know. Maybe it is, but I can't say that either. Like I can't say aluminum. I can't. Wait, wait. Isn't aluminum isn't that Latin? It could be. It could be. hmm Always Grateful says, it never ceases to amaze me the amount of people who see things which are obviously parody and post or tweet and swear it's true because they saw it online. Oh my God. Yes. You're with me. I'm glad. I'm glad some of you are with me on these. Yeah, very much like I think Mallory might be able to help me pronounce aluminum, and I should ask her. Right, Recker? I should ask her. Yeah, Mallory could help me with that. All right. The turtle moves. Twitter is open to free speech as long as you don't make fun of Musk. Exactly. Somebody watched our show. Thank you. Yes, and this was quite timely to what's going on. Obviously, this case, Novak versus Parma, has been going on for years, as I explained in the beginning. And I did link you to the wiki and both of these briefs so that you guys could read it again, while on the toilet or, needing a little laugh or, trying to figure out what the hell I actually said when I mispronounced everything. Like it's down there for all of you to read later because, hey, this isn't going away. I am very vested, seriously, in what actually happens with the outcome of this. And yeah, I get it, Charlie. Squiggly words, squiggly words. I should have I should have just just put my Mallory on when I tried to pronounce all that stuff. It would have been much easier, Yeah. Nope, we're not in the same room. Not right now, we aren't, Ricker. Stop that rumor right there. Don't be talking like that. Don't be talking about like that. Just stop it. All right. All right. But I'm let me get through this one. All right. Now this is the Babylon Bee. Okay. And just so that you know, they are a conservative satirical newspaper. They also do articles. You got to go read them. They did one on Elon Musk that's hysterical. His, mm, I thought it was terrible. Something about, a sink. I don't know. Go check it out. We could talk about it later. But for now, let me just read you the Supreme Court of the United States amicus brief presented by the Babylon Bee as amicus curiae in support of the petitioner. Okay. But is it? All right. First, again, the table of contents, because here the snark starts. They're going to do the interest, the summary of the argument, but here are the arguments. Argument number one: parity is essential to a free society. Argument number two: the Sixth Circuit's rulings allows the government to punish vast swaths of constitutionally protected speech. And three, where qualified immunity deprives the speaker of civil remedy, acquittal for a criminal speech charge is cold comfort. Cold comfort. And look, case law, more case law, more case law, and some quotes from actually the Babylon Bee and other magazines. All right, so the interest of the Amicus Curiae. All right. The Babylon Bee is a dangerous, far right misinformation site. Okay, now there's footnotes already. Interest of the Amicus Curiae, footnote 1. No counsel for any party authored this brief in whole or in part, and no individual or entity other than the Babylon Bee and its counsel made any monetary contribution intended to fund the preparation or submission of this brief. Timely notice of intent to file this brief was provided to counsel of record for all parties, and the same have consented in writing to its filing. Okay. The Babylon Bee is a dangerous, and there's a footnote. Libby Evans, CNN reporter, claims the Babylon Bee is dangerous from an article January 7th of 2020. Okay. The Babylon Bee is a dangerous far-right misinformation site. Footnote number 3 from the New York Times: far-right misinformation site The Babylon Bee uses satire claim to protect its presence on Facebook from March 22nd of 2021 that typically peddles fake news. In another footnote, and I'm going to stop reading these pretty soon because they are going to footnote every single quote that they say. I believe me, this one's short. I put it down there for you. I recommend that you pull it up and read it yourself. The footnotes are lit, but so that we can get out of here before midnight, I think I'll just excuse them for now. So let me start again. The Babylon Bee is a dangerous far right misinformation site that typically peddles fake news, but when its writers are up for a more challenge, occasionally uses satire to draw on and reinforce actual misinformation and conspiracy. The Bee is part of the conservative media ecosystem, famed for its conspiratorialism, conspiratorialism and questionable reporting. The Bee has made some success with the whole satire thing, with 20 million page views per month on its website. The Bee is quite possibly the most popular source for satire in the history of the world. The Bee has inspired many imitators, including our fellow amicus curiae in this case, a cute little upstart known as the Onion. Like Mr. Novak, the Bee is frequently the target of censorship and attacks from powerful people who don't get it, or at least don't appreciate, its jokes. The Bee has faced the ire of a diverse group of establishment media types, including the New York Times, the Washington Post, and CNN, and the wrath of the massive tech companies who functionally control the lion's share of public debate in our society. As a matter of fact, the Bee is serving a brutal life sentence in Twitter jail as we speak. Its writers would very much like to avoid a consecutive sentence in a government run facility. Summary of the argument: truth is stranger than fiction, and fiction is illegal. at least in the Sixth Circuit. That court's decision depriving petitioner Anthony Novak of any opportunity to hold accountable those who searched his home and arrested him and jailed him because the parody he wrote was too effective should be reviewed by this court on the merits. First, parody plays an invaluable role in a free society. When parody is imperiled, citizens are deprived of one of their most effective means of criticizing the government. Second, the Sixth Circuit's ruling will allow the state to punish vast swaths of speech erstwhile protected by the First Amendment. The Bee and its writers could be held criminally liable for many, if not most, of the articles the Bee publishes. Good grief, the Bee could even be on the hook for publishing this brief's doppelganger. Third, the prospect that an individual or entity charged with a speech crime might ultimately be vindicated at a criminal trial does little, if anything, to temper the speech chilling effects of the decision below. And when they say that they published a doppelganger, if you go to the web page, they did. They posted a whole dummy one in support of the government. That's even funnier. Um, I was going to read that later for you, but I think you should go read it yourself. Third, the prospect that an individual or entity charged with a speech crime might ultimately be vindicated at a criminal trial does little, if anything, to temper the speech chilling effects of the decision below. The Sixth Circuit's qualified immunity on steroids approach means that state actors can search, arrest, jail, and prosecute offenders like Mr. Novak without fear of ever being held to account themselves. Knowledge that they may be searched, arrested, jailed, and prosecuted without recourse is enough to dissuade most would be speakers, regardless of the potential for ultimate acquittal. And now we go to the arguments. Number one, parody is essential to a free society. The Onion may be staffed by socialist wackos, but in their brief defending parody to this court, they hit it out of the park. Parody has a unique capacity to speak truth to power and to cut its subjects down to size. Its continued protection under the First Amendment is crucial to preserving the right of citizens to effectively criticize the government. Furthermore, parody shouldn't be stripped of constitutional protection just because it's not clearly labeled as parody, and requiring that parody be written so as to ensure that the most gullible in our society, the Facebook using grandmother, the tween TikTok addict, and the CNN reporter, don't take it seriously, ruins the parody for everyone else. The Sixth Circuit's decision undermines these fundamental principles, and this court should grant Mr. Novak's request for a writ of certiorari in order to right the free speech ship. The Sixth Circuit's ruling allows the government to punish vast swaths of constitutionally protected speech. Argument number two. Police. The Sixth Circuit has previously said cannot punish a peaceful speaker as an easy alternative to dealing with a lawless crowd that is offended by what the speaker has to say. That comes from case law, Bible Believers versus Wayne County. But that same court's ruling in this case means that police can punish a peaceful speaker if they are the ones offended. Ohio Revised Code 2009-09.04b makes it a felony to knowingly use any computer, other electronic device, or the internet so as to disrupt, interrupt, or impair the functions of any police, fire, educational, commercial, or governmental operations. In Mr. Novak's case, the Parma PD, backed by the city law director, a magistrate, and a municipal court judge, concluded that by creating his Facebook page, parodying the Parma Police Department, Mr. Novak had violated, or probably had violated, that statute. Therefore, the police reasoned he at minimum deserved search, arrest, jail time, and criminal prosecution. And the Sixth Circuit didn't disagree. concluding that the police came close enough to getting it right to entitle them to qualified immunity. That is, respondents reasonably found probable cause in an unsettled case judges can debate. Novak versus City of Parma. The Sixth Circuit reasoned that officers were permitted to rely on inferences to establish the knowledge element. No one contests that Novak used a computer and the internet to create his page, and the officers could reasonably believe that the calls to the department alerting it to the parody's page existent constituted a disruption. Probable cause, or at least close enough to probable cause to justify a few nights in jail. Left in the hands of the Sixth Circuit in the Parma PD and other like minded law enforcement, the speech stifling Ohio statute used to go after Mr. Novak empowers state officials to search, arrest, jail, and prosecute parodists without fear of ever being held accountable. The upshot for the B is that in Ohio at least, its writers could be jailed for many, if not most, of the articles the Bee publishes, provided that someone contacted law enforcement or another entity protected by the statute to tell them that the articles exist. Take a simple example. Last March, a headline from the Bee trumpeted donut sales surge as police departments refunded. The Babylon Bee from March 3rd of 2022. Funny stuff. But suppose someone, anyone, had called the Parma Police Department to let them know that the Bee had published the article. In Ohio, the Bee could have been charged with a felony, its offices searched, and its writers arrested and jailed for days, all without consequences for the parties doing the charging. Arresting, jailing, and searching. And what if Officer Riley or Officer Connor's passive aggressive brother in law had forwarded the article to one of them as his official police email address? And heaven forbid, Officer Riley or Officer Connor then had opened the email and read the headline while on the clock, thus interrupting his workday. Ohio Revenue Code 2904.B, same result, a search, arrest, and felony charge for the B. As with other news organizations of similar caliber and eminence, local police are a regular focus of the Bee's hard hitting journalism, but their federal counterparts star even more frequently in the Bee's digital pages. It was the Bee, after all, that first reported on these antics at the FBI. FBI storms convent to arrest group of dangerous pro-life extremists, and FBI gets night's sleep after raiding My Pillow Guy. But the Bee would be safe from the wrath of Parma's finest and their ilk in these circumstances, right? Since the FBI is a federal agency and not an agency of Ohio or one of its subdivisions. Wrong. The Ohio statute makes no distinction. See the Revenue Code again. And thus had a caller contacted the FBI field office in Cleveland or Cincinnati to inquire about one of these stories, or to express outrage over the suspicious timing of the FBI's raid on Melania Trump's Mar-a-Lago closet and Attorney General Garland's acquisition of the hot culture wardrobe, the B would have been subject to a felony charge and writer jail time under the Ohio statute for disrupting, interrupting, or impairing government operations. Hmm. And there could hardly be a more open and shut case for the enforcers of law and order in Ohio than that of the story the Bee reporting on testimony before the House Judiciary's January 6th committee. I thought I was going to die, says Capitol Police officer who held door open for protesters on January 6th. The article concluded with this self-incriminating line. The FBI has issued a warrant for the man who called the officer a cupcake and is asking anyone with information to call Nancy Pelosi's office immediately. That story is, by the Sixth Circuit's lights, dripping with probable cause. After all, the article explicitly asked readers to play their part in disrupting, interrupting, and impairing governmental operations by calling the Speaker of the House and thereby momentarily inconveniencing one of her staffers. Mm. All this is only the tip of the iceberg, as the statute criminalizes not only disruption, interruption, or impairment of police or governmental operations, but also disruption, interruption, or impairment of fire, educational, or commercial operations as well. Thus, the bee and its writers could be variously subjected to search, arrest, jail, and prosecution for the publication of hundreds of articles unrelated to policing or other government operations. Consider college athlete surprised to learn his school has classes. Had a reader called the Office of the Academic Affairs of the Ohio State University about that article, that would have been enough for law enforcement, without fear of being held to account for themselves, to arrest the Bee staff for disruption of educational operations. Ohio Revised Code 2909.04b, likewise with the articles, Aaron Judge sets record for most home runs by person with a normal sized head, and Subway begins promotional offer where they will use real meat for a limited time. Had someone contacted the Guardians or Reds about the former, or an Akron Subway franchise about the latter, then it's goodbye freedom for the team at the B. Per the decision below, Parma's boys in blue could reasonably find probable cause at that point and therefore search, arrest, and charge jail without impunity. Oh, with impunity, sorry, from Novak. In short, vast amounts of protected speech are swept up in this criminal prohibition of alarming breadth. United States versus Hernandez Calvillo. Oh boy. And quoting from the United States versus Stevens. When local police and federal appellate courts, officials, both high and petty, join forces to execute and then condone the search, arrest, jailing, and prosecution of parodists for protected speech, the very core of the First Amendment is rendered a dead letter. Here, here. West Virginia State Board of Education versus Barnett. Argument number 3. Where qualified immunity deprives a speaker of civil remedy, acquittal for a criminal speech charge is cold comfort. Mr. Novak ultimately was acquitted of the felony charge leveled against him, and the Bee hopes that, when its turn comes to face the Committee of Public Safety in Ohio, the result might be the same. But this court should not confuse acquittal in circumstances like these with vindication of the robust free speech rights enshrined in the First Amendment. This goes to the most troubling aspect of the Sixth Circuit's decision. Certain passages of that opinion give the impression that the court's sympathies lie with free speech. The court, for example, purports to regret that neither the police officers nor any of the other state officials involved ever put the brakes on the search or the arrest or the jail time or the criminal trial wrought upon Mr. Novak. But the aggressive form of qualified immunity the Sixth Circuit adopted, in fact, gives state officials a blank check to continue suppressing speech via these same means. The court had its doubts about the rectitude of respondents' actions, yet it chose to shield them from liability anyway. Hmm. The Sixth Court, the Sixth Circuit, purported to lead the parties in a state of relative parity. At the end of the day, the court opined, neither side got all they wanted. Little did Anthony Novak know that he'd wind up a defendant in court. So too for the officers who arrested him. Hmm. But in fact, the contrast between the parties' positions could hardly be starker. The Sixth Circuit's decision allowed respondents to deal a fell blow to Mr. Novak's First Amendment right to criticize the government, while at the same time leaving Mr. Novak without any means of redressing this grievous constitutional violation. True, both Mr. Novak and respondents were, as the court's opinion says, defendants at one time or another. But Mr. Novak was a criminal defendant, subjected to the ordeal of a criminal trial, including the fear of imprisonment, the public humiliation, and the financial strain that entails. Curiae versus Virginia case law. And he was not just any criminal defendant. He was a criminal defendant and search subject, an arrestee and jail inmate who hadn't done anything wrong. Yet he escaped criminal liability only because a jury adjudged him not guilty. Respondents, by contrast, were mere civil defendants, and even though they had violated Mr. Novak's First Amendment rights, still they were afforded the luxury of avoiding a trial altogether. Moreover, they lost Mr. Novak's criminal case. Respondents still managed to get what they wanted: thorough and efficient suppression of Mr. Novak's speech criticizing the police department. They intimidated Mr. Novak into removing his Facebook page, and then, by arresting him, searching his apartment, jailing him for 4 days, and hoisting a criminal trial upon it, made it all but certain that he and anyone else paying attention would never commit a similar speech crime again. The only means Mr. Novak had to counteract this thorough-going suppression was to lodge an ex post civil suit against respondents in hopes of holding them accountable. There was and is no other effective remedy available to him or to the countless others whose federal constitutional rights are similarly abridged. But the Sixth Circuit closed that door to Mr. Novak, leaving him bereft of recourse. To an aggrieved party, a right without a remedy is doubtlessly not much better than no right at all. Case law, Triad Associates versus Robinson. The B has no reason to believe that the result would be any different should Ohio authorities choose to bring parody in violation of that statute, charges against it or one of its writers. Sure, if the B were to roll the dice with a jury, sanity might prevail, but that is by no means assured. And even if criminal trial victory were in the bag, without a means to dissuading state actors from continuing to arrest and jail speakers they don't like, any such victory really would be just a less extreme loss. The writers at the B are a hardy bunch, accustomed to regularly and brilliantly observing blows from powerful, prestigious media outlets and also from CNN that desperately want to muzzle the bee. Child's play. But whining establishment types who are unable to take a joke and who possess the coercive power of the state are an entirely different matter. Add to that mix the aggressive, unbridled strain of qualified immunity propagated by the Sixth Circuit, it's enough to make Chuck Norris sweat. Conclusion. The Babylon Bee respectfully asked this court to grant Mr. Novak's petition for a writ for certiorari. And on that, I'm done. I shall remove myself from my soapbox of parody support and free speech and say that I had a lot of fun. And I hope you didn't mind me reading all of that, but it just had to be done. It needs to be immortalized on YouTube. Spread it around. Pass those briefs around. Yes, it's parody, and there's nothing like supporting parody with an amicus brief to the Supreme Court full of freaking parody. I digress. Anyway, thank you for your time today, people. This is an actual law case. This is actually up to the Supreme Court to decide again because they asked for the second review. And it's real. And it's funny because it's real. Yes, I did say that. Yes, Rocket Couch, pass those briefs around. It's parody. It's hysterical. It's actually a legal quagmire right here, but it's also important. So everybody weigh in. You know, put your thinking caps on and think. Think for a little bit. Everything that's going on Twitter and all the other social media platforms, everybody crying about getting their accounts suspended, this and that. Talk about bringing back accounts that have incited riot against the government. You know, I do believe in free speech. Of course I do. I'm a damn YouTuber. I'm out here talking all the time. Some of it's sensible, some of it not. But on this, let's just think about it a little bit. Where are the lines? We have to get ready for this battle. This is a serious battle. This battle is going on in courtrooms everywhere right now, and it's going on social media on every damn platform. It's on YouTube, it's on Twitter, it's on Facebook, it's on TikTok, it's everywhere. Instagram too. Everywhere you can think of. Even that other one that Trump started, What Maldon, it's going to be everywhere. It's on Twitch. It's everywhere. It's on every social media platform there is. Free, free speech. Where are the lines? Where does it cause harm? Where does the First Amendment have to stop for the good of the people? This is the thing. hmm But do we have to jail parodies because somebody made fun of them? Elon Musk recently suspended a whole bunch of accounts that made fun of him. hmm I would imagine maybe he's going to sue the bee. Who knows? I don't know. But seems like people get their fifis hurt. They kind of act a little weird. Hmm. Anyway, it's a good question, and it's going to keep coming up. And I've got my hat on about it, and I'm thinking about it, and I hope you all are too. Even if this was really fun, it was serious at the same time. Those briefs were lit and dripping with parody and free speech. You think they're going to get arrested? I mean, after all, it's all about Ohio. Yeah? And they got some serious statues there. And is it really necessary to use the immunity clause to protect from civil lawsuit when they really get that crazy? Yeah, because did it really cause that much trouble? Did it? Did it really? Where's the line? That's what I want to know. That's the question of the day, people. And on that, I'm going to let you go. Thank you for your time. Thanks for letting me read out loud. I love to do it. And when it's parody, I love it even more. Check out The Onion. Check out Babylon Bee. Check out the actual real deal on the Wikipedia for the law case below because this is real. Um, and Anthony Novak, I support you. I thought that those posts were funny as hell. And if you want to see those posts, check out the Wikipedia because they're going to be in there. Okay. On that, I just have a couple of announcements. One of them is a YouTube thing. Like, share, comment. You know the drill, people. Let's get into the algorithm. Let's get this going a little bit. So I'm here to talk to you even more. Okay. And if you want to become a member, hit the join button or hit the Patreon, whichever. And on that, one of the perks is access to the Discord. And I only mention it because you all keep asking. But that's how you get in. That or do a show with me. On that, you can become somebody who wants to discuss something like the Twitter debacle that's going on recently because my mate Chris from Hereticals, Atheist Pastor, he and I are going to be talking about the Twitter debacle tomorrow at 7 o'clock. And we shall hopefully see you there because that's going to be something because we're on opposite sides of it, actually. But nothing like some good, honest discourse and people with respect talking respectfully about opposite opinions. Let's see if we can do it. We did it last time when we talked about Roe versus Wade. Let's see if we can do it about Twitter. Okay, but that'll be tomorrow. Wednesday, that'll be on my channel, Sandy, 7 o'clock tomorrow. Right here, right back here. And then Wednesday, we'll be again updating you on the Masterson trial some more. And that's getting like, it'll be right here on my channel, Sandy, it's 7 o'clock. And on that, I'd like to thank you all for being here. Thank you again to my moderators. Thank you to everybody who showed up and listened to me just read on and on about the most ridiculous stuff I've heard in a long time. But anyway, um, I hope to see you tomorrow and have a great night. Bye.